Mistake number 2, when we don't control our financial and property matters during incapacity. Okay, something happens to you. We're not talking about being disabled. If you're disabled and your mind is still functioning, you can still sign checks and pay bills and collect income. But if something happens to your mental capacity, your ability to function properly, then what you typically have to do is go down and get a conservatorship. And we have a very persnickety probate judge here in Lane County. She's an excellent judge, Lauren Holland, but she will make you jump through hoops that are expensive and time-consuming to set up a conservatorship. That's a situation where someone's appointed to manage your money, but that someone's got to hire somebody like me, has got to file annual accountings of every dollar that is spent to the nearest penny, and has a visitor come in and check up on you to make sure you're doing a good job. So there's a lot involved there. And these are the kind of phrases people use to describe a conservatorship. If you establish a living trust and you become incapacitated, the successor trustee, you're going to be your own trustee of your living trust. The successor trustee, your spouse, close friend, whoever, can step in without missing a beat and continue to collect your income and pay your bills and take care of you financially without ever having to apply for a conservatorship. And we're going to talk a little bit more about living trust as we go through the seminar this evening. A durable power of attorney is a very valuable companion to a living trust when it comes to taking care of you from a financial standpoint when you're incapacitated. The durable power of attorney authorizes your agent to also take care of your financial affairs, but to do a few things that your successor trustee in a living trust can't do. For example, someone with a power of attorney in their hand can put your home up for sale and sell it for cash funding if you need that. They can deal with the IRS. They can go to the bank and deal with your safety deposit box. And do several other things that a successor trustee won't do. So they complement one another. Now, powers of attorney are very powerful instruments, and they can cause a lot of trouble if they're given to the wrong people. I had a daughter come in, she was about 50 years of age, worried about her mother, who was 80 and frail, who was financially abused in a big way by her caretaker. This caretaker ingratiated herself to the financial care to the lady, and wound up embezzling $400,000 from the lady's insurance company where she had annuities on deposit. And she did that by using a valid power of attorney that she talked the elderly lady into signing over to her, the caregiver. And when the daughter came to me, she said, "Can't we sue somebody to recoup this money?" Well, I did a bunch of research, and of course the caregiver herself was in jail and penniless, and the insurance company acted on a duly signed power of attorney. So I couldn't find any red flags that would have called this problem to the insurance company's attention, so I had to tell the daughter, "I'm sorry, the insurance company did what they were supposed to do under a valid power of attorney." So I generally recommend your spouse or a very, very trusted child or friend be the limitation on who gets to be the agent under these powers.